On that note, we do have some email questions, and our first one comes to us from John. And John wants to know, when the law says a property owner, quote unquote, should have known about a dangerous condition on their property, what are some examples of that? And I always get concerned when you start using things like should have known, those types of phrases. That's kind of like pointing the finger, don't you think?
No, it goes above just I guess, a cursory inspection. It's a standard in the law, which is called knew or should have known of the defect, even though it's not apparent to the naked eye. If it's we just had one, BJ. You remember the I won't say the name of the
Yeah, I think I know what you're talking about.
You know what I'm talking about?
Yeah, I do. Yeah.
Tell the audience about that. It was a pretty interesting case.
Well, if we're thinking about the same one where the lady was walking into a restaurant and stepped on a piece of plastic.
Yeah. It was a little round piece of plastic about the size of the face of a clock in the ground that was supposed to be for drainage, but it was made of plastic. And when she stepped on it, her heel went down into it. She fell and broke her hip.
Wow.
Well, the knew or should have known applies here because it was of plastic rather than metal. And the owner should have known that over time that plastic would disintegrate or deteriorate, at least to the point that it wouldn't hold the kind of weight that was put on it.
And that gets back to, I'm sorry, let me interrupt you.
Go ahead.
Yeah, that gets back to, the ultimate test Carl mentioned too early on is the superior knowledge as between the landowner and the person that got injured. And you have to prove that they had superior knowledge, either that they had actual knowledge, which it means they knew about it, or they had constructive knowledge is what the should have known means. So if you can establish the owner had actual or constructive knowledge and you didn't, or theirs was more than yours, that's when they're accountable for the injury.
Well, how would an actual person or just a consumer coming into your place of business have that type of access? How would they go about trying to establish, you should have known better than to have this right here? Because, most of the time when buildings are put together or situations like that, they just, follow the builder's lead. But as a person who gets injured, you got to go back and try to prove that with your attorney or take pictures and that type of thing.
Yeah, those are evidentiary issues, and they're not really all that fact intensive. But let me give you an example. Let's say you go to a friend's home and they have a front porch that is just board siding, and you step on it and it breaks. You go through it and you break your leg. Well, if you can establish then that board had been weak and it kind of had a spring to it over a period of time, and you went there and you had no knowledge of it, but the owner did have knowledge of it, then that's actual knowledge. There's also a duty to inspect. I mean, he could be knew or should have known that was a weak board in the premises, and you had no knowledge of it, then the owner may be liable to you for the injuries you sustained.